Good morning to everyone. Today I'm here to speak to you about how to protect your business IP. And I'm just going to go on to the next slide. What I'd like to do during this presentation is discuss types of IP, IP protection, IP ownership, IP audits, and then have a brief conclusion. But before I start, I have a poll question, and Nicole's going to, I think, send it out. And the poll question that I have is, do you think you have intellectual property in your business? And if you think yes, press number 2. And if you think no, press number 1. I'm going to let Nicole then give us the results to this question. Oh, that's so perfect. I say that to you because I've been doing this for a very long time, intellectual property and technology law, over 25 years. Years ago, had someone say to me that they didn't think they had any IP in their business, which was unfortunate because everyone has IP in their business. The question that I want each of you and all of you that are present understand that. And the question that I want for you now to consider is my IP valuable? Because as you'll see, it's not cheap to protect IP, and some IP you may not want to protect, and that's okay. But at least you've done the analysis to come to that conclusion. So if you have a piece of paper and you have some time as I'm presenting, do a table, and then the first column will be type of IP, and I'll tell you what to do there in a moment after I talk about this little cartoon that I love starting my presentations with. So you have two people, and one says to the other, I invented fire, but now everyone is using it for free. In hindsight, maybe my first invention should have been intellectual property law. And unfortunately, this situation is still happening in businesses today. Businesses are allowing others to take their IP. And what happens when that happens? One, you lose competitive advantage. And number 2, you also lose the prospect of earning revenue. So now let's go into the first column that I was talking to you about. If you have time to do a little table, column 1 would be types of IP. That's the first thing we need to discuss is what type of IP do you have in your business? And so as I'm speaking and describing the 4 common ones, which I've listed in this PowerPoint slide, patents, trade secrets, copyright, and trademark, maybe jot down some notes as to what you may have in your business. Note that there's other types of IP. So these are the 4 common ones, but I consider domain names, business names, corporate names, plant breeder registrations, industrial designs, integrated circuit topography, all of that are examples of IP. But I'll be talking about the 4 common ones today. So now let's move on to patents. So patents protect inventions, ideas that you may have. And if you're able to get a patent issued on your invention, you will be able to stop others from making your invention. And if you have an issued patent, you get a monopoly of 20 years, both in Canada and the United States. The point that you need to realize is that there's no such thing as an international patent. It's all national in scope. So you do have to figure out what countries you will need to protect where you think you're going to be making money. Examples of inventions are, for example, you may have a process, you may have a machine, you may have a composition, you may have an improvement to an existing invention that's out there already. All of those are examples of inventions that you may be able to get patent protection on. Okay. One of the concepts that I always discuss with my clients when we're talking about patents and protecting ideas and inventions is the concept of disclosure. So the main point I need, and this is a key point that I want everyone to take away from today, if they do have an invention that they'd like to protect, is you can't be disclosing it to anyone on how it works, because if you do that and there's no confidentiality obligation tied to that disclosure, then you may have lost the ability to get patent protection in most countries of the world. There are a few countries that realize that people make mistakes and that they'll do a disclosure without a confidentiality obligation tied to it. And so they've granted grace periods. So Canada, fortunate for us, is one of those countries. What does that mean? If you have done a disclosure without no confidentiality obligation tied to it, then you have 1 year from the date of disclosure to get your patent application in. Now, when I talk about disclosure, you may be thinking, oh, she's talking about, maybe getting together with a friend over a glass of wine or a beer and just discussing my great idea or invention and how it works. That is an example of a disclosure. And that's common sense will tell you that. But other examples of disclosures are on this PowerPoint slide. Conference presentation. So you may be invited to be a keynote speaker at a conference to talk about a medical device, for example. And you go and you start explaining to the audience how that medical device works. That's a disclosure. A lot of businesses do file grant proposal applications. If you put too much detail on your invention in those grant proposals, that could be a disclosure. Trade shows, if you have a prototype and you put that on your table at a trade show, that could be a disclosure. So you have to be very careful that you're not disclosing. Now, sometimes I do get calls from clients saying, oh, I just realized about the disclosure concept, and I am going to San Francisco, for example, to do a keynote presentation at a medical conference, and I fly out in 2 days. So what am I going to do now? Because I am thinking of getting a patent application filed. And so the way I describe it to clients is there's sort of two categories of patents. The first category is what I call provisional patent applications, and the second category is what I call a full patent application. And the benefit and the pros of a provisional patent application is that they're quick, so within a few days we get that in for you, and they're cheap. You're probably, those are the pros. The con is that they're only good for 1 year, but it allows you during that 1 year to figure out what you want to do. And then as the year is approaching, then you have to ask yourself, do I want to keep going with this invention and protecting this invention using patents? And if yes, then you've got to file a full patent application before the due date, before that 1 year due date. If you disclose, if you want to disclose your invention to a third party, then my advice is, which is on this PowerPoint, is get a confidentiality agreement. Another word for that is a non-disclosure agreement, because that's tying a confidentiality obligation to the disclosure. So what are the benefits of getting a patent? Because they're not cheap. And so you want to make sure that you're using your money wisely. The first, and I got 3 points here in my PowerPoint slide on the 3 benefits. I mean, the main reason is it prevents your competitors on a global basis, depending on where you filed, from using your protected products or methods. But the other benefits that you may not think about is you get an issued patent, which is a certificate, and it's tangible, and you're able to present that. Or you get a pending patent application, which is a piece of paper, and you're able to present that to investors. They see a document describing how your invention works, what the specifications are, what the claims are, versus having you describe what your invention is without giving them any documentation. So it's tangible, and investors just feel better seeing something, and that you've also put money to try to protect it by filing a patent application. And then the last benefit is you are able to make money if you have an issued patent or a pending application by entering into license agreements with third parties and charging them a royalty to use the invention or make the invention or sell the invention. And then so you get this royalty stream. And IBM is a very good example of a company that's been doing that for years. So those are patents. Trade secrets. Trade secrets go hand in hand with patents. Because the way what I say to my clients is, who come with an idea or an invention, I say, okay, here's the patent process. Here's the cost. And depending on what they say and what their invention is, sometimes I have to say, okay, how easily reversed engineer is your invention? Could I easily reverse engineer it? And if the answer is yes, you can, then you do really have to focus on the patent process. But if one of my clients says to me, no, it's very difficult, Sylvia, for anyone really to easily reverse engineer my invention, then we talk about trade secrets, because the patent process, you're making a deal with the government when you file a patent application and get an issued patent. And the deal is, listen, if you get an issued patent, you'll get a 20-year monopoly. But after those 20 years are up, your invention now will become public, and everyone in the community could use it, because we want to make society better. So you have a 20-year period. Whereas with a trade secret, the pro on a trade secret is there's no expiry date, there's no application process. And the only way to protect trade secrets here in Canada is under common law, judge-made law. And what that says is, in order for you to have a trade secret, and I'll describe examples of that in a minute, is you have to keep it secret. No one could be told about it, and it can't get into the public. And the minute it gets into the public, then it's no longer a trade secret. And examples of trade secrets would be data, manufacturing techniques or processes that you have in your plant, for example, formulas, recipes. And if you're able to keep those secret, because some of those could be not easily reversed engineered, then you may want to consider keeping it as a trade secret. And the only way that I tell my clients that you protect trade secrets is by entering into agreements that have strong confidentiality obligations in them, where the person signing promises that they're not going to be disclosing your trade secrets to any third party. And so the benefit of a trade secret is no term, and Coca-Cola is a good example of that. It's a recipe, and no one's ever filed a patent on it. They've used trade secret protection, and it's been around for a long time. And your trade secret is not made public by the government, for example. The third type of IP that I like to talk to you about is copyright. And copyright automatically vests the minute someone creates a tangible original work. And under our legislation, there's 4 types of works. I've got it on this PowerPoint: literary, artistic, musical, or dramatic works. And so the minute you do that, you automatically get copyright. And for originality, it doesn't have to be sort of a Van Gogh level. That's not the test. The test is, I described to some of my clients, me picking out, getting my notepad with my pen and doing a stick person. That probably qualifies as original under the test under Canadian law. So you don't have to have Van Gogh style for it to be original. So a lot of works that become, a lot of these literary, artistic, musical, or dramatic works that become tangible get copyright protection. And so what does a copyright certificate give you if you file an application? It gives you the right to be the only one to reproduce all or substantially all of the work. So if it's a book, for example, and you've got copyright in that book, or if it's software code, for example, and you have copyright in that software code, it allows you to prevent others from copying all or a substantial part of that book or that code. And on this PowerPoint, I have examples of copyrightable works. We've got the databases, we've got the blueprints, written specifications, experimental techniques that have been put down into a logbook. We've got computer software, manuals, for example. And on my next PowerPoint slide, what are the benefits of getting copyright protection? Because in order to protect a copyrightable work, you don't have to, you can register an application with the Copyright Office. And the reason why you would want to do that are 2 reasons. One, it's cheap. The government fee is about $50 to $65. You could do it online. You'll get a certificate emailed to you. And you don't need a lawyer. I tell my clients, you don't need me to fill out your copyright application form. It's a simple application form. Making mistakes is very hard to make. And there's instructions on how to fill that application on the CIPO, C-I-P-O copyright database. But the biggest benefit of paying your $50 or your $65 government fee is that if you get that certificate and there is copyright infringement and you want to stop someone from using your software code, for example, a former employee or a former contractor, then the onus shifts onto the bad person to show that he or she did not steal your code. If you don't have the copyright certificate, then the onus is on you to show that he or she did steal the software code, and that onus can be hard to meet. So for $50 or $65 government fee, it may be worth for you, if it's a valuable copyrightable work, to get that copyright certificate by filing. The last point I want to make with copyright is there's another concept called moral rights, and that ties into the copyright world. The copyright is the economic benefit. The moral rights are the following. There's three rights, and they're the following. Number one, the creator of a work has the right to have his or her name associated with that work. Number two, the creator of a work has the right to prevent modifications to that work if it's going to prejudice his or her reputation. And the third right is the creator of the work has the right to prevent his or her work from being associated with something if it's going to prejudice his or her reputation. So why am I letting you know that? If you are dealing with copyrightable works, never forget about moral rights, because if you do forget and you don't get them waived by the creator, it doesn't matter that you paid $100,000 for the software code. If you didn't get a moral rights waiver from the software developer, then you have a chef in your kitchen that may be able to dictate how you run your business with respect to that software code. So so you have to get a waiver, and it has to be in writing. So don't forget that point. The next concept or type of IP that I like to talk to you about is trademarks. And trademarks, examples of them include a logo, for example. And on this PowerPoint slide, you see the World Trade Center logo with the globe above World Trade Center words. That's a trademark. All of your businesses will have a trademark. Another example is just a word. So World Trade Center would be a trademark. We had massive changes last year in June of 2019 to the trademark legislation. And one of the changes was the expansion of what a trademark is. And so now you could get a trademark on smell. Before you could, now it's codified. You could get a trademark on sound. If there's a solid color that you use for a particular good, you could get a trademark on just a color. So very wide as to what a trademark is. And so what's the purpose of a trademark? A trademark is used by a person, you, to distinguish your goods and services from those of your competitor. It's used to prevent your competitors or others from passing off their goods and services as yours, especially if you have very strong goodwill, a very strong brand. One of the points that I want to make is that in Canada and the United States, we still have the prior use concept, but in other parts of the world that does not exist. And so in some countries, it is first to file, and it's not if you used first. So for example, a lot of my clients file in Europe. Europe is a first to file. I don't care if you were the first one to ever use that particular trademark. If you haven't filed and someone comes ahead of you, you're out of luck. In Canada, it's a first to file system. What I mean by that is if I file your mark first and then you come after me, the trademark examiner, the trademarks office, will deal with my application and will stop yours and allow me to proceed. You would have then to file an opposition to stop mine, which increases legal fees and time and costs. But if you were the first one under common law in a particular province to use that trademark, doesn't matter that I filed ahead of you. if you have prior use, you could stop me. And that's the law in Canada and the law in the United States, but not everywhere else. So it becomes important for you to consider getting applications in. The other reason now in Canada why you may want to get your application in if you were thinking about it and you have a valuable trademark is because one of the changes that came into play last year eliminated the concept of use at the trademarks office. In the old days, in order for my client to be able to get a certificate of registration for their trademark, my client would have to say in either an application or in a declaration, yes, I promise I have used my trademark on my goods and services, and we would file that with the trademarks office. That got eliminated with the changes in the law last year. And so what does that mean? That means that we now are experiencing in Canada trademark trolls. What are those people? Those people file applications at the trademarks office for other people's trademarks. And they are able to get certificates of registration because they don't have to promise or show use of the trademark on any goods and services. And so what does that mean for you? It means that if you find that happens and that someone went ahead and got a certificate of registration on your trademark or a confusingly similar trademark, then you may have to look at litigation. And that comes in the form of either going to court or in the form of an opposition or in the form of an expungement. All of that costs money. And that's a lot more expensive than filing a trademark application and getting your mark registered. Something to consider. One of the issues that comes up a lot, believe it or not, is trademark symbols. And you've all seen it. It's the little TM on the top right-hand corner of a trademark or the R in the circle. Those are trademark symbols. Canada, we have no laws on how to use them. But in the US, there are laws on how you could use the R in the circle. And in the US, you can't use the R in the circle unless you have a registered trademark. Now, me personally, I think the TM is a lot more known to people and they know what it means, that you're giving notice that you have a trademark in that particular word or logo, for example. And I see more use of TMs than the Rs. I say that to you because a lot of my clients have marketing collateral that they use for both Canada and the United States. And that saves them money because they don't have to have two separate pieces of marketing collateral for each country. They could use one for both. But they've got to be careful because they can't be using the R in the US unless they have a registered trademark. So in order to just keep that one set for both countries, the TM is used. So it saves money on the marketing collateral and also keeps them out of trouble. So what's the trademark benefits? There are, I describe to my clients, two categories of trademarks. There's the common law trademark, and then there's a registered trademark. The minute you use a word or a logo, for example, as a trademark, you automatically get common law rights under our common law judge-made law in that word, in that logo. So now you're thinking, well, then why would I want to pay you then to get a registered trademark, Sylvia? The reason is because common law rights are very restricted. So if you're in Manitoba and you've used that trademark only in Manitoba, then you only have rights in Manitoba, not across Canada. But you may have plans to expand across Canada. And so let's say you decide to expand into Alberta, and you find that someone else has now used your trademark in Alberta for similar goods and services, and you have a common law trademark. Well, you won't be able, and that person was first in Alberta, you won't be able to stop him or her. And the passing off action, if you are the prior user and you want to stop someone who's stealing or infringing on your trademark, you have to use the passing off action, which is a difficult test to meet under common law. So those are the pros and cons. On a registered trademark, yes, you pay money to get it registered, but once it's registered, you've got protection all across Canada. So if you're a Manitoba business and you start here with plans to expand, but it takes you 5 years, for example, to get into Ontario, and then you find that someone has used your trademark in Ontario, but you were the prior user in Manitoba, now you've got a registered trademark, and you're able to stop that person. So it gives you time to expand across Canada, to expand your business. And the other benefit of getting a registered trademark is there's more rights in the legislation that you could rely on to try to stop infringers. So it just makes your life a lot easier if you have people stealing your trademarks. So that's the first part, types of IP. You've got your table in front of you, first column, types of IP. Hopefully you've jotted down. Now the second column will be how valuable is each IP that I've listed on my column 1. And you may find that some of it's not valuable, and that's fine, because at least you've done the analysis to come to that conclusion. Now I'm going to do a polling question, and Nicole's going to put it up. And the polling question is, can investing money in protecting IP increase the value of your business? If it's no, it's number 1, and if it's yes, it's number 2. And that Harry is not just your competitor. That Harry could be an employee or a contractor. And if you're not careful on protecting your IP, it will be stolen. And that video showed you some easy ways that third parties could steal your IP. So on your table that you've got, if you have identified IP that's valuable, then the next column will be, where do I want to protect it? Because as I've said earlier, IP is national in scope. So you do need to consider if you need to file in foreign countries. So that column lists the countries that you think you're going to be making money. Costs will vary from country to country, and I'm able to help on that because our firm is one of the members of Lex Monday. We were a founding member actually many years ago. And so that gives us access to some top law firms in each country and in each state. And I use Lex Monday and members of Lex Monday a lot for my clients because I file all over the world. And we have had really no problems dealing with Lex Monday members. They've been pretty good. And then my last point there is consider registering in countries that have weak IP laws, like China, for example, or Russia. In China, if you want to have any leverage to go after infringers, you do need to have registrations, either a copyright registration or a trademark registration or a patent registration, or even just to consider litigation. The next concept I want to talk about is IP ownership. And so in that chart that you've got, do another column and then ask yourself, who is the owner of each type of IP? And don't assume that you are. And so here's the 2 common myths that people have. The first one is the employer is automatically the owner of all intellectual property created by its employees. That's not always the case. For example, under the Copyright Act, there is a section that says that if an employee is hired to create whatever the employee in copyrightable works creates, will be owned by the employer. But then the question becomes, okay, if there's no agreement and copyrightable works were created, were they created within the job description or outside of the job description? Now you have this gray area and it's not clear whether it's the employee or the employer who should own. The next myth is the customer is automatically the owner of all the intellectual property created by its independent contractors. I don't care if you've paid a developer or a contractor $50,000 to create something for you. If there's no agreement expressly stating that you, the business, owns that IP, the general rule is if there's no discussion on IP, it's the contractor that owns the IP. And I've had a lot of situations over the course of my career on this point where people have paid quite a bit of money to have others create IP, thinking they own that IP, and then a problem occurs, and then I get the call, who owns the IP? And I go, can I see your agreements? We have none. is there any emails or any discussions on IP and ownership? No, we've never had those discussions. And so now I have to say to my client, I'm so sorry, but I don't think you own that IP. So very important that you know about these myths. How do you solve them? To avoid the necessity of making legal arguments on whether IP, invention, works are owned by you and are not disclosed by anyone, you need to get into agreements. So I have a list of 3 documents here. The first one is the employment agreement, or the services or independent contractor agreement is another word for it. Employment agreement is for your employees. Independent contractor agreement is for your contractors. Just make sure that each of these agreements, 1, you use them. 2, make sure that there's intellectual property clauses in there that expressly state who owns the IP, what can be done with the IP. It talks about assignments and disclosures and moral right waivers. So my clauses, my IP clauses in these documents are quite extensive because I want to cover off and make it very clear and remove sort of as much gray area as I can from my clients, that ownership and anything that's IP related stays with the employer or the business owner who's paying for the development of the IP. And the next document is the non-disclosure agreement or the confidentiality agreement. What I tell my clients is anytime you are going to have a discussion with anyone about your invention, your idea, your technology, get them to sign off on confidentiality. And that can be done through the NDA. And that allows you then to have those forthcoming discussions about what you want to do and how that person could help you. And then the last point is consider having written policies on IP ownership and protection of confidential information within a handbook, for example, for your employees. And if for key employees, you may want them to sign an acknowledgement every year on these particular policies that they recognize that they exist. IP audits, what I've been hired to do sometimes with my clients is everything that I've just presented to you on, they hire me to go and do that table that I told you to consider doing, where I identify all the IP. I then look at any ownership issues by looking at agreements and having discussions with the client. Identify any encumbrances, claims, and litigation that may pertain to the IP. So you may want to consider doing an IP audit if you have valuable IP. I've talked about Lex Monday, which we're a member of, and I use Lex Monday to protect IP outside of Canada for my clients. And on this PowerPoint, I wanted to just give you 2 examples of 2 matters that I've been involved with: the correct way and the consequence of not doing it right. The correct way was one of my clients, a medium-sized business, and they got bought by a big multinational, and it was a big deal. And when you have a big deal and you're a vendor, you have the purchaser sending their team to do all the due diligence. And so that was done by the purchaser. And the main asset that was being sold was a bunch of intellectual property. In fact, I say that, I had a meeting at one point going through the share purchase agreement with the client and discussed, you had to sort of allocate the purchase price. And the client said, everything is IP. You could put a few thousand for this, few thousand for that, but everything's IP. And so it was the correct way of doing it because we closed that deal within 4 months, and it was a massive deal. But we were able to do it because this client believed in IP. They protected their valuable IP. They had all the agreements in place. When the due diligence team came from the purchaser, they had all the binders and the virtual data room was populated, and the team was able to look at it, and they didn't find any serious issues on the IP. And so we were able to close right away. The consequences of not doing it right is an example where one of my clients was an investor and wanted to invest in a startup technology company out in San Francisco who's about to go bankrupt. And so I got retained to do the due diligence and to see that what he was buying was actually what he thought he was buying. And so there was a patent portfolio, industrial design portfolio, there was trademarks, and there's a bunch of non-disclosure agreements, a bunch of employment agreements. And so my team, we looked at all of that. And then we just found, there was over 100 non-disclosure agreements. And a lot of them were different. And then there were terms in there that didn't make sense, or at least would not make sense for a company to have agreed to. Then we looked at employment agreements, and some, not all, but a few had joint ownership with the employee. Well, my client is not paying for joint ownership. We're paying for the company to be the sole owner of all IP. That's who we're investing money in. So how do we now get rid of another chef in the kitchen? And so we had to deal with those issues. And I remember getting a call from the founder of that San Francisco company saying, like, could you just try to get this done because I'm going to go bankrupt? And I said, I wish I could, but we've identified all of these issues and we've got to get them rectified. And so on joint ownership, for example, I said to him, I need your employee to sign an IP assignment saying that he has no interest in this invention because the company has to be the 100% owner, no one else. And so that's why it's slowly, we need other people to sign off on things because it wasn't done properly. And so that's not what you want to be doing. You want to be doing it the correct way. And doing a table or getting an IP audit done will help you sort of figure out where you should protect in case you need to get an investment, in case you decide to flip, for example. Thank you very much.
I did have one question. How is it first to file in the US? In the US,
it's like Canada. I mean, again, if you want to get your application in sooner than later, but let's say it's later and someone gets ahead of you, it still comes down to who used it first in a particular state. And so it's state-based, like it's province-based here. It's not all, you don't get protection. Just because you were the first one to use it in the States doesn't mean you get common law protection for all of the states. You get it in that particular state. And so that's the prior use concept that exists in both Canada and the United States.
Okay, great. What is the most common mistake you see clients making when it comes to IP?
I mean, the most common and most expensive is IP ownership. And honestly, people don't know about those myths. They really do think that once they pay someone to create for them, that they're the owner. We paid for it, but that doesn't work that way. And so there's always a lot of surprises. And so I just want people to take away today the notion that you've got to get it in writing. You want to be in writing, very clear that I own the IP.
Okay. Can I use trademark when purchasing without purchasing it legally? Is there a downside to that, to doing that?
I don't understand that question.
Because it says, can I use TM without purchasing legally? If maybe somebody who sent that question, if you guys could maybe clarify on that. And I do have another one, so we'll wait for clarification on that particular question. Is trademark office similar to copyright office?
No.
Just a form or one fee for, or one fee can do on oneself?
No. So I direct everyone to the Canadian Intellectual Property Office website. It's Government of Canada, and the abbreviation is CIPO, C-I-P-O. And copyright is totally separate and apart from trademark, which is separate and apart from industrial design, which is separate and apart from patents. I give you that because when you go onto the database, you will see copyright, you'll see the trademark, you'll see the patent, you'll see the industrial design. And so you're going to have to click on the one that you need to protect. But copyright is, if you make a mistake, there's not serious consequences. Whereas if you make a mistake on the trademark, on the patents, and on the industrial designs, there could be very serious consequences, and you may think you have protection, but you really don't. So that's why I say to clients, you need to retain me or another professional to help you with that. But on the copyright, it's easy peasy, and there's instructions on how to do it.
Great, thank you very much. In regards to the question previously, you mentioned that there were no laws in Canada for when you use the TM trademark.
The TM symbol.
Yeah, the TM. So can you just start using it?
Yes, you can. And I encourage all my clients to use the TM symbol on all of their marks. Because you're putting notice, you're giving notice to people that you consider that particular word or design as a trademark. And you want to be giving notice so people don't steal your stuff.
Mm-hmm. That's a really good point. Is there anything else that you would recommend for people, like where to start? Is it, maybe going to the CIPO website, or, what are those first steps? Because it can be, overwhelming and a lot of
Yeah.
different things to consider.
I mean, I honestly direct everyone to CIPO website. You will see what I'm talking about when you go on. There are so many resources. They've also made it easy to understand with some use of roadmaps, for example. There's also just simple examples that they use when describing what could be protected with that particular type of IP. So I would highly encourage everyone to go there. It's a great start.
Great, that's excellent. And I'm just going to see here. Is there a downside in using the TM symbol without legally filing for protection of your logo or name?
No, not for the TM symbol. Again, even remember I was saying there's two categories of trademarks, the common law and the registered. I tell clients that have common law trademarks to put the TM symbol after their trademark.
Okay, great. And we have a thank you for the great article on TM changes in Canada. Would love for you to explain the changes or renewal fees in Canada.
So renewal fees and classification were some of the big changes. There's a lot of big changes that came into play last year. Okay, on the renewal fees, in the old days we would pay $350. Okay, so maybe before I even go there, in the old days, Canada was not part of the Nice International Classification Treaty. What that meant was when I filed a trademark application, or when I filed a renewal of my client's trademark application or registered trademark, I would just describe all the goods and services that they're using their mark on. So, I would put shoes, and then I would put clothing, and then I would put, online retail store, or I would put, manufacturing services or retail store services, and I would list everything. And in the old days, when I filed that, $250. And if I had to renew that, $350 government fee. Then now we've got the classification system as of last year. What does that mean? Shoes, I got to figure out using that treaty, what number does shoes fall in? I think it's class. I'm still learning all the classes. There's about 44 classes. So I have to figure out, where does shoes fall? Okay, class 21. Okay, where does clothing fall? Oh, that's class 25. Where does retail store fall? Oh, class 35. Where does the online presence? Oh, class 42. So now you've heard me say 4 classes. And on the renewal, you've got to move all those goods and services into these classes. So now when I file a trademark application, I got to say to my client, okay, you've got 4 classes. The government fee is $330 for the first class, $100 for every additional class. So with 4 classes, you're looking at 530, and if it's 6, so 530 government fee. And on a renewal, I'll say to you, okay, you have 3 classes. So the first class is $400, and I think every additional class is $125. So the government fee has gone up. And you have to classify, and you might get a letter, like I get letters on behalf of my clients, I'm their agent, where the trademarks office is asking me to classify the goods and services under the treaty, because these marks were registered before the treaty became law in Canada.
So a lot of things to consider.
Yeah.
We have another question. Trademarks. How important is the descriptor when filing goods or service? Is the industry that you're operating sufficient? Example, insurance services, or do you need to describe all aspects of the business?
It depends. I say that to you because my practice is to be as general as I can when describing goods and services for my clients, because every business evolves. And a trademark registration now, in the old days it was 15 years, now it's only good for 10 years, but 10 years is a long period. Your business will be changing in 10 years. And so I try to use general language. So for example, I would use insurance services, which can mean a lot of things. But depending on the examiner you get, who's looking at your application, they may look at that and say, I think insurance services, Sylvia, is too general. And they'll get pushback and they'll say, I need more detail. And so then you may have to say insurance services, comma, namely, comma, auto insurance, comma, home insurance. Like, but I try to avoid having to do that second part because maybe in 2020, we just have auto, travel, and home. But 7-8 years from today, there may be, I don't know, digital insurance, like something totally that none of us are contemplating. And so then you go back, then you look at your trademark certificate, and if you don't, if it doesn't include the digital insurance, for example, then you don't have registered trademark protection on digital. You only got registered trademark protection on what's described in that app, in that certificate. So I try to be general as far as I could get it, instead of narrowing. And so that's experience from me having done this as to what I think is going to be accepted by the examiner and not in the trademarks office, for example.
Correct. If wanting to protect your business nail/work mark, would you want to protect your trademark across Canada? Would you recommend incorporating federally registered the trade name in every province or filing a federal trademark? Oh, okay. So it's business name. Sorry, just corrected.
That's fine.
Yesterday I got caught with a technical term and I thought, well, maybe you'll know the word.
So there's 3 concepts in that question. The first one is business name. The second one is corporate name. And the third one is a trademark. They're all different. And you can have one word with all 3 hats on it. Or one word could be all 3. So a business name is provincial. And so, and it's not an entity, it's provincial. And so every province has their own laws on how they issue out business names. So for example, you may be able to get a business name in Manitoba, and then you go to Saskatchewan to carry on business and you can't get it in Saskatchewan because someone's already ahead of you. Or there's a confusingly similar business name and the government says, so now you're stuck, can't use it in Saskatchewan. The corporate name is either provincial or federal. And on the provincial, same issue that I just described to you for business name would apply on a provincial level to a corporate name. But at the federal level, no such thing as a federal business name, but there is a federal corporate name. And one of the strategies that we use if we have clients who want to be able to go across Canada, but are taking time to do that, and want to be able to have their name available once they get to a particular province, we file a corporate name federally. And then because of our constitution, it gives them priority over provincial names. And so when they go into Alberta, for example, let's say it takes them 2 years and there may be a provincial name there that's confusing, similar to the same, but because they're federal, they may trump. So that's different though from a trademark. A trademark is federal, but I've talked to you about the category common law, which is provincial. And that's one of the restrictions, that's one of the cons of having a common law trademark. It's based on the passing off provincial, and you get protected within the province. On a federal trademark, again, as I mentioned earlier, once it gets registered, then it gives you the ability to expand. A corporate name and a trademark are different. A trademark is a word or a logo that distinguishes your goods and services, that ties to your goods and services. A corporate name or a business name does not. It's just the name of your business. So there's different concepts. Having said that, if you have a registered trademark, the Trademarks Act does look at business names and corporate names when trying to figure out who has prior use. Now, you've heard me talk about this prior use concept in Canada, United States. Our legislation requires us to look at what corporate names, what business names existed prior to the registration of the trademark, for example. And we could use that in order to assert rights.
Great. Well, thank you very much. We have, are you okay? We have 3 other questions and then we'll close out the webinar, but a lot of really great information. So somebody says, I've tried to register my corporate name federally, but it was too general. What strategy would you suggest in choosing a name?
So, and that does happen to me too. You just have to add another element, which is another word. And so just pick another word. In that particular case for my clients, I just try to get a descriptive word that sort of describes the business and add it to the name that you tried to register. And that could be your first. It could be the first word or the second word. I mean, you figure out what you want to do, but just add another element.
Great. In a startup company in the R&D phase, would one register the product name right away during the prototype phase, even before the product is commercially available?
It's up to you. You can. And I mean, the old days we used to call that a proposed use application, where clients would get the application in. There was no use of the trademark yet in Canada. They had the intention of using it, but and the reason why we filed a proposed use was because we didn't want people to steal it. Now, that concept no longer exists in Canada because of the trademark changes that happened. But yes, you can. And I would, and if you think someone's going to take it, you may want to get that application in before it becomes public. But note this: once your mark gets registered, you've got 3 years to start using that mark, and from the date of registration. And if you don't, and there's a competitor out there who wants that trademark, they may try to expunge it. So know that just because you got a registered trademark doesn't mean you could sit on it. You have to use it. And right now it's a window of 3 years.
Great. Can somebody have a trademark registered and someone else have a federal corporation with the same name?
The reason that happens is, and not to say that it's okay, right? Because this is where I do the analysis on when there's an infringement for clients. But on trademarks, you can't get, and on even corporate names, you cannot have a confusingly similar corporate name and trademark. So what do I mean by confusingly similar? Are the goods and services under the corporate name and under the trademark the same or similar? Who are the clients? Are they similar clients? What industries are impacted by the corporate name and by the trademark? Are they similar? What channels of trade are being used under the corporate name trademark? Are they similar? There's under Section 6 of the Trademarks Act, there's a list of criteria that we look at for analysis on infringement. And if there is a federal name, a corporate name, that's exactly the same or confusingly similar to a trademark, and they're in the same business, same clients, same channels of trade, there may be potential infringement there. Yes.
Okay. And so somebody else mentioned, so in other words, a trademark trumps the federally incorporated company?
Not necessarily, because under the Trademarks Act, it says that you can't get a trademark if there's someone that's using a business name, corporate name, prior to your use of the trademark that's confusingly similar. So the Trademarks Act treats corporate names and business names akin to a trademark when doing an analysis on infringement. So I could use a corporate name to stop a trademark from going through.
Okay. And this one is our last question. I'm hoping it won't be too lengthy for you, but can you expand on the process of licensing / royalty stream for an issued patent?
Okay. So once you have, and you don't have to have an issued patent, even if you have a pending application, if you know that there's a third party who would be interested in either making, selling, exporting the invention, the technology, if you know that someone exists, or if you know of people who may be interested in doing what I've just described with your technology, you approach them. Get a non-disclosure agreement signed, you approach them and say, listen, I've got this invention, I've got this technology, I've got a pending application, or I've got an issued patent. Are you interested in manufacturing this technology, this machine? And if the third party says, yeah, I am, I think this is a great machine, great piece of technology, I think I can make some money on it, then you enter into a license agreement. Because there's only two ways of dealing with IP. You're either the owner or you're a user. And if you're a user, that's reflected with a license agreement. And so if you have a third party who wants to be a user of your invention, of your patent, then you enter into a license agreement. And then in that license agreement, mean, the grant clause is a critical clause where you explain what their rights are when using your patent. And then the next, I think, for most business people would be the what I call the consideration clause is how do I get paid? Like, how do I get my royalties? And on what basis? Net sales, gross sales, lump sum payment, is there milestone payments? Like, and when do I get paid? And so all of that goes into the license agreement.
Okay, great. Well, thank you very much. Merci, Sylvia, for all this great information on this brand new How to Protect Your Business IP webinar, and for all of you of joining us. I really enjoyed today's session. And is there any disclosure in regards to the information that you provided with us today, Sylvia?
No, and people could, yeah, they could do whatever they want with it.
Okay. Please note that the WTC Winnipeg is here to help you any way we can. We are a reliable and trusted resource during this difficult time. Feel free to connect with us by phone by filling out our business information request form, as well as other resources that have been just sent in the chat box. We hope that to see you at our upcoming webinars. Do check out our lineup for October. It is on our website. And join us for a great partnership webinar with the Winnipeg Chamber of Commerce on October 23rd, Navigating the Marketing Challenges of COVID-19 with 6P Marketing. Have a nice day. Bonne journée. Stay safe and healthy.
Thank you.